Good morning, everyone. Welcome to today's client seminar on drugs and alcohol in the workplace. I'm Darren Gardner, Head of Workplace Law and Culture here at Barty & Perry. With me today is Linda McKinlay, partner in the team as well. And in presenting today from the Sydney CBD, we acknowledge the Gadigal people of the Eora Nation, traditional custodians of this land from which we present, and pay respects to elders past, present and emerging. We are so pleased to present this topic for you today because it's had so much interest. And in fact, I think this session is one of our most well-attended seminars in our client series since they started many years ago. And I think it may be because with the changing nature of work, including now what is considered to be our workplaces, there's a renewed awareness of the intersecting challenges you as HR professionals face managing drugs and alcohol in the workplace. So before we begin, I'd like to go over just a few items on how you can best participate in today's event. There was actually so many people here we couldn't do it in person anyway, so but you'll have an opportunity to ask questions at any time during the webinar by typing your questions in the control panel. That's part of the screen that you have. We will endeavour to answer your questions at the end of the presentation. You'll also receive a copy of our slides and the recording afterwards, and we'd appreciate it if you could fill out this short survey on the conclusion. It helps us actually choose topics that interest you and ensures that we get the interest that we've got for this event. So now let's begin. What Linda and I plan to discuss with you today are what the obligations in terms of safety with drugs and alcohol, instances where it is the employer's responsibility or concern, mandatory testing regimes and issues, discrimination, management, and then at the end there'll be time for questions.
So good morning, everyone. Firstly, today we'll be looking at obligations and safety. So drugs, alcohol and other substance abuse in the workplace is, as with any health and safety risk, it's everyone's responsibility. And safety risks can arise with the use of drugs and alcohol in the workplace, and it follows that individuals may be placed at greater risk of injury if they're impaired, and they might also place others at risk of injury. So under work health and safety legislation, employers have a duty of care to ensure so far as is reasonably practicable the health and safety of workers and others. Workers also have their own work health and safety duties and obligations. And for example, under Section 28 of the Work Health and Safety Act, while at work, a worker must take reasonable care for their own health and safety. They also need to take reasonable care that their acts or omissions do not adversely affect the health and safety of other persons, and they must also comply as far as reasonably able with any reasonable instruction that is given by their employer to allow the employer to comply with their own work health and safety obligations. And they must cooperate with any reasonable policy or procedure of the employer that relates to health and safety at the workplace that's been notified to workers. So there are some employers and workers who will have additional safety obligations, and that's by virtue of the type of industry in which they operate, and there may also be specific legislative requirements given the specific risks that working in those industries presents. And some examples of those specialist fields includes the rail and healthcare industries. So in the rail industry, there's the Rail Safety National Law, New South Wales 2012. Under this legislation, rail transport operators have duties to ensure, so far as is reasonably practicable, the safety of their railway operations. But furthermore, a rail transport operator must ensure, so far as is reasonably practicable, that rail safety workers do not carry out rail safety work in relation to the operations of the railway operator and are not on duty while they're impaired by drugs or alcohol. In the healthcare industry, there's the Health Practitioner Regulation National Law, New South Wales, which provides that health practitioners and their employers have mandatory reporting responsibilities. Registered health practitioners and their employers must tell the Australian Health Practitioner Regulation Agency, otherwise known as AHPRA, if they have formed a reasonable belief that a registered health practitioner has behaved in a way that might constitute notifiable conduct. And notifiable conduct by a registered health practitioner includes where they're practicing while intoxicated by alcohol or drugs. Now, in terms of employer policies and employer values, these are other obligations that could be derived from workplace policies on drugs and alcohol, and it supports employer efforts to comply with their own work and health and safety duties. Policies also assist employers to instil their own corporate values and make clear to all workers what behaviour is acceptable in the workplace. An employer may wish to consider its stance on drugs and alcohol depending on the services it provides. For example, an employer whose employees drive plant and operate equipment may legitimately have a stronger stance on the use or positive test results of drugs and alcohol than another employer due to the associated risks that arise in such a working environment.
Well, let's ask the question, when it is an employer's responsibility or concern to regulate drug and alcohol use by employees, and in the traditional sense, there are three areas. So in the workplace, at a work-sponsored or organised event, but also there can be instances where outside of work, there is some connection to work or the reason why that event is outside of work. Some environments where work is performed invite tolerance. Indeed, many organisations encourage social functions where workmates can celebrate significant events or in achieving personal, professional goals, to do so over a few drinks, at a lunch, or at an organised social event somewhere where there may be alcohol or even drugs being consumed. But where's the line? There are other workplaces, as Linda's just mentioned, where there would be a zero tolerance. And this is because the zero tolerance approach would be mandated by legislation, particularly for high-risk industries, as Linda's mentioned, in rail, health and other industries. But also if the type of work that's being done makes it not reasonably practicable to tolerate a safe level of drug or alcohol use, because the risk to that person or others is too great. Indeed, other organisations have value reasons. So if there may be religious or moral values where alcohol or drug use is incompatible with the beliefs, tenets, or reputational interests of the organisation where people work. And we've also noticed that there's some intention now with some of these concepts where, particularly over the last couple of years, where people, extreme measures have been taken in terms of managing pandemic risks, and people have been working away from employer-controlled workplaces. The nature of how these risks may manifest has also changed. And the lines between acting or carrying out work in a private capacity or in a personal, professional capacity are blurred now more than ever. A number of interesting questions arise when you look at the changing nature of being at work or at a workplace, particularly when you look at how to apply levels of tolerance or intolerance where in an era of flexible work arrangements. So, and then leading from that, how does an employer reasonably assess risks of impairment or being affected by drugs and alcohol when you've got people working from home or at remote work locations where you don't have a personal or direct contact with that employee? Well, we've had to think about this in preparing this presentation, including looking at, well, how do decided cases assist answering some of these questions? On the question of, and this happens quite often when we are asked to advise on work health safety risks, and there's a suspicion of impairment by drugs or alcohol, it's often said, well, look, as a reasonable manager, you need to rely on your own senses and experience in the first instance to suspect that somebody may be affected or impaired by drugs or alcohol at work. And a good example, even though it's a case now that's 10 years old, is at Niebauer and Johnny Crow's Garden Childcare Centre. There, the employee only had 1 year's service, so not a great sort of period of time to assess them and their habits in life. But there, the employee turned up to work smelling of alcohol, and the employer, as a childcare centre, had a duty of care under Education and Care Services national regulations that applied to it as a childcare centre. And indeed, as an approved provider of education and care services, it had duties to ensure that children who were being educated and cared for were in an environment free from the use of tobacco, illicit drugs and alcohol. And this duty also extended to ensuring that a supervisor or staff member or volunteer at the centre was not affected, so they were words used, by alcohol or drugs, including prescription medication, so as to impair his or her capacity to supervise or educate or care for children. And there was actually, under those regulations, there was a penalty of up to $2,000 and risks to the operator licence if there was breach of that obligation. So as I mentioned, the employee, Ms. Niebauer, turned up in April for work, but was immediately directed to go home as she smelled of alcohol. And in fact, the witness who gave evidence said it was a strong smell of alcohol. The employer was invited to an interview about it and had been interviewed about previous concerns, including from a parent of the centre who had also said that she had smelled alcohol on this person before. And there was also a staff complaint who had said that they were concerned about Ms. Niebauer being aggressive towards them and some children at the centre in the months prior. At hearing, the childcare centre said that Ms. Niebauer, during her interview, admitted she was had drunk alcohol. However, at hearing, Ms. Niebauer denied this. And so you've got the classic scenario of somebody who suspected, smelt it, relied on their senses, the employee denies it. The Commission, however, accepted evidence from the witness that Ms. Niebauer smelled of alcohol, and that was sufficient to have a reasonable concern. However, the Commission had some difficulty about whether or not Ms. Niebauer was impaired or affected by alcohol in a way that the regulations imposed the duty. And in fact, it was found that if the childcare centre suspected she was impaired or infected by alcohol under those regulations, it should have stood her down from duties and requested that she be available for a blood alcohol test from a medical practitioner before she could resume duties. So, and this was found to be something that might apply in circumstances to other employers in similar situations. Thankfully, though, the Commission acknowledged that this was no ordinary workplace, and it was a workplace where there were young children and toddlers involved. The employee herself, Ms. Niebauer, knew that there was a concern about prior complaints, that she had smelled of alcohol before, and she had placed her employment at risk at that time. She was also aware that the childcare centre that which she worked operated within a regulated environment, and that her colleague, having smelt alcohol in her breath when she turned up to work on the last occasion before dismissal, was enough to support the finding that she was affected by drugs and alcohol. No unfair dismissal was found. There was a valid reason for the dismissal, and one of the valid reasons was that the employee, knowing these things and these duties she had and her employer had, ended up eroding trust and confidence in her, including by her own admission that during the interview, which that she was drunk, and the Commission did not accept her evidence in denial at hearing. So it sort of begs the question, though, that in this case, if we weren't dealing with a childcare or high risk environment, and the employee had not had previous incidents of suspected sort of drug or alcohol use or being affected by it, would it have been a different outcome?
And picking up on that point about different workplaces, the second case that we wanted to talk about was John Pennawan trading as Rose v. Hair, Face, Body and versus Domingo, which was a 2012 decision of the full bench of the then Fair Work Australia. And unlike the childcare centre in the previous decision, Rose v was a small hairdressing business, and it was a small business for the purposes of the Fair Work Act and the application of the Small Business Fair Dismissal Code. So the facts of this matter, Mr. Domingo was employed by Rose v as a hairdresser from January 2007 to May of 2011. And Mr. and Mrs. Pennawan were the salon owners, and they also worked in the business. Now, in May 2011, the salon owners became concerned about Mr. Domingo's ability to perform his role as a hairdresser. They were particularly troubled by some of his actions, his unprofessional appearance at work, and some behavioural issues that they had been experiencing. On one occasion, in May of that year, Mr. Domingo came to Mr. and Mrs. Pennawan's house in the early hours of the morning, and he was acting erratically and claiming that someone had set his apartment alight. They took him home and found that there had actually been no fire. They did, however, overhear a conversation between Mr. Domingo's cousin and ex-partner, and that conversation was that Mr. Domingo had been using drugs for a long period of time. The day after that incident, the salon owners were told that Mr. Domingo was admitted to hospital for reasons related to mental illness and drug taking. Now, while Mr. Domingo was in hospital, Mr. Pennawan sent a letter informing him that his employment was terminated with immediate effect. And the reason that was given for the termination was that the business was not doing so well due to the financial crisis. Subsequently, Mr. Domingo lodged an application for unfair dismissal. Now, it came out that during the proceedings, the real reason for his termination of employment had nothing to do with the financial crisis, but was due to the risk of injury to a customer or employee from Mr. Domingo's behaviour and drug taking. Now, at first instance, the Commission found that Mr. Domingo had been unfairly dismissed, and that was in part due to the summary dismissal of his employment. So on appeal, the full bench held that the termination of Mr. Domingo's employment was not an unfair dismissal because they found that it was consistent with the Small Business Fair Dismissal Code. Now, in considering the paragraph in the Small Business Code allowing for summary dismissal for serious conduct, which includes serious work health and safety breaches, the full bench said that there were two steps to determining whether an employer had satisfied the aspects of the code. The first step was it's necessary to consider whether at the time of dismissal, the employer believed that the employee's conduct was sufficiently serious to justify immediate dismissal. Secondly, it's necessary to consider whether that belief was based on reasonable grounds. And that second element incorporates the concept that the employer had carried out a reasonable investigation into the matter. It's not necessary to determine whether the employer, however, was correct in the belief that it held. Now, the full bench expressed some concern about the salon owner's failure to discuss Mr. Domingo's conduct with him. Whilst normally, in order to hold a belief on reasonable grounds, it's necessary to have a discussion with the employee about that perceived misconduct and pay regard to their explanations, the full bench suggested that this was a very unusual case. They did, however, say that the evidence established that Mr. Domingo had displayed erratic behaviour while at work and also away from it, which the salon owners had directly observed, including when he visited their home at 3 a.m. in the morning. Now, in this case, the salon owners were concerned about the impact on their business of Mr. Domingo's drug taking. He was responsible for opening the salon on time, and they had experienced problems with his reliability and attendance. They were also conscious of work health and safety implications of his erratic behaviour. Now, in finding that it was not an unfair dismissal, the full bench held the employer was very small. The owners knew the hairdresser well. They directly observed his behaviour. They believed that he had made lifestyle choices that involved drug taking, and this directly related to his capacity to perform his work. His work involved close personal dealings with clients, and at the time they made their decision, the hairdresser was hospitalised. They were conscientious in considering the grounds for summary dismissal in regulatory material available on the internet, and in these unusual circumstances, we're of the view that the employer, when considering the hairdresser's recent erratic and unusual behaviour, formed the belief that he had engaged in conduct that justified immediate dismissal on reasonable grounds. Our conclusion, however, should not be seen as one that would necessarily be reached in all cases of out-of-hours misconduct or drug taking.
Well, as you've heard, both of these cases concerned specific employer-owned and controlled workplaces. The hairdresser one interests me because one would think that it's not incompatible as a hairdresser to be a drug-taking hairdresser, and it's interesting the hairdresser didn't argue the risk of bad haircuts, but in terms of a childcare centre, it's somewhat a bit more understandable. But in both of the cases we've looked at, it's clear to see that there could have been arguments too that as persons controlling a business or undertaking, there were duties so far as reasonably practical to eliminate, control and prevent workplace risks, including the risks to clients or children. But in sort of the context of working from home, how do we assess these types of risks? And I know many during COVID where remote and working from home arrangements were necessary did consider unique risks associated with home-based work. Those risks tended to be, from our experience, some of the ones we've identified up there, they're not a complete list, but issues such as being isolated from other workmates or the workplace and the mental health risks associated with that loss of connection. There was also risks not usually associated with employer-controlled workplaces, such as domestic violence risks. And in fact, there's been decided cases about the risk of domestic violence at home being a reasonably foreseeable risk. There's also, perhaps not as commonly thought of, but it probably did cross people's minds as to how people at home have freer access to drugs and alcohol with less oversight and supervision or control over that sort of behaviour. And it's particularly difficult to assess the risks when people are working flexibly too, where hours are not certain, but so long as work product is delivered within ranges of time, how do you know whether or not within those hours drugs or alcohol be consumed or used at home in the home environment? And more importantly, how do you, based on the cases of suspicion, detection and assessment that we've discussed, how do you assess risks when interactions are often not in person or are online, and yet the nature and importance of the work being done has not changed, it's just the way it's being done is different. Some may argue that there's an increased risk and greater risks of home-based work, but let's explore some of these issues using a hypothetical and a simple one, but we've got a team member who has been appearing dishevelled and acting unusually, mainly on Microsoft Teams calls, because that's the way most meetings are being conducted. There's a particular Microsoft Teams call with this team member involved in a group of other people in the meeting, and you observe in the room, sitting on a shelf, drug paraphernalia. Now, assuming that this is not some unusual virtual background and it's actually in their home, workplace in real life, what do you do? Now, depending on the nature of the meeting and how many people you've got involved and where those people come from, there are a number of possible responses. I welcome any responses you may wish to give in feedback now, but one response could be, well, look, because there's a group meeting online about something that is work related, you may not want to raise possible personal health or welfare issues in front of other people, or even perhaps raise a potential reputational risk issue if you've got external stakeholders on the call. Do you direct the employee to log off and make themselves available for a private discussion afterwards? That might be one response. In that separate discussion, do you ask them directly about the drug paraphernalia that's visible in their work setting at home? And do you actually ask them, is it something that they have used during work hours? I would suggest yes, because how on earth could you assess the risk or express the concern you have? Now, depending on the answers the employee may give, including if you believe what they're telling you is true or not, it may be that the nature of the work they do, even though it's being done from home, is serious in that you are relying on their work product for other people to make important decisions about that may affect others. So it could be something as simple as them doing a research project or collating data that actually then needs to inform someone else to make an important decision that may present risk to someone. It may be appropriate in that situation to be arranging for an in-home drug test to determine as soon as possible whether or not that employee is impaired or affected by drugs or alcohol at home. Of course, that may raise the question, well, what if the employee doesn't allow that to happen in their home? One suggestion could be to issue a lawful direction that they make themselves available at a specific location at a certain time for that testing to take place. It would arguably be a lawful and reasonable direction based on that suspicion. Another response could be, do you put in place new specific policy measures or issue specific directions to that employee? For example, that based on the suspicion and what has been seen in the Teams call, they are not to consume any drugs or alcohol during any work hours at home? Or is it something broader than that, that any work day they're not to do it and to not have drug paraphernalia sitting visibly in their home work environment? Again, I think you could reasonably enforce such a direction as being lawful and reasonable. The employer may argue otherwise or claim, for example, that it's not their paraphernalia, it's a flatmate or someone else's. But again, I think they would need to assume some responsibility for how the workplace looks when on professional calls. But what if the employee admits that the drug paraphernalia is theirs, but it was only used for work out of work hours, and they even claim that it in no way impairs or affects their working hours performance? Again, you may consider whether or not to test that proposition. You could also be that it's not just a work health safety risk that you're dealing with. You've got an organisation or business that is responsible for providing healthcare or drug or alcohol prevention services, or you have a organisational corporate reputation where you do not wish to support or you do not sponsor the use of drugs, alcohol, by anyone because it's incompatible with the products or services that you provide. What if the clients that you have are on the call during that time? What do you do with them? I don't think there's any simple answers, but again, the scenario is there to sort of propose sort of issues that could be acted upon. But let's look at some other situations where we can answer some of these questions.
So picking up on that out of hours issue and when things occur out of hours, we're looking now at out of hours conduct. And the primary issue that you need to think about is there a link to the workplace? In other words, is there a connection between the out of hours conduct and the employee's employment? Now, to establish whether there is a sufficient connection with their employment, employers will need to give consideration to a number of things, including is there or will there be reputational impacts? Could there possibly be relationship impacts? Is it contrary to employers' interests? Is it incompatible with employees' duties as an employee? Is there due to this type of conduct, does it impact workplace cohesion and safety? And is there a derogation from corporate standards, such as policies and the like? Now, in cases involving out-of-hours conduct, it's usually not enough for the employer to simply assert that the conduct will in some way affect its reputation or impact the capacity or ability of an employee to perform their role. There'll need to be some further evidence to support those assertions. And we discussed in an earlier slide the decision in John Pennawan Trading and Domingo, which was the full bench decision of the Fair Work Commission. On the issue of out-of-hours conduct, the full bench stated in that case that generally employers have no right to control or regulate an employee's out-of-hours conduct. But if an employee's conduct outside the workplace has a significant and adverse effect on the workplace, then the consequences become a legitimate concern to the employer. And so now we'll run you through some of the cases that deal with out-of-hours conduct with respect to drugs and alcohol. So there are some circumstances that have been recognised by the courts as ones in which out-of-hours misconduct by an employee may constitute a valid reason for dismissal. In the case of Rose and Telstra Corporation Limited, it's a seminal case in this area. Vice President Ross stated that it's clear that in certain circumstances, an employee's employment may be validly terminated because of out-of-hours conduct, but such circumstances are limited to the conduct must be such that, viewed objectively, it's likely to cause serious damage to the relationship between the employer and the employee, or the conduct damages the employer's interests, or the conduct is incompatible with the employee's duty as an employee. Now, the test to be applied is that, in essence, the conduct complained of must be of such gravity or importance as to indicate a rejection or repudiation of the employment contract by the employee. So in Rose and Telstra Corporation, the facts of that matter were that Mr. Rose was involved in a fight with another employee, and this decision was from 1998. So it's fairly old, but it's still very relevant. So he was involved in a fight with another employee while he was off duty, but he was on a work trip that was funded by his employer. And the Commission held that Mr. Rose's conduct lacked the requisite connection to his employment because the incident took place outside of working hours. The employee was not wearing his work uniform and he was not on call at the relevant time. The incident also took place in a hotel room, which was not a public place, and accordingly it was that there was no evidence that the reputation of the employer had been tarnished by what had occurred. It was therefore not accepted that Mr. Rose's conduct, objectively viewed, was likely to cause serious damage to his employment relationship, and he was therefore unfairly dismissed. Another more recent case about out-of-hours conduct involving the use of alcohol is the 2019 case of Trudy Pushka and Ryan Wilkes Proprietary Limited. This is a Fair Work Commission decision from 2019. In this case, the applicant was employed as a project administrator and a major client of her employers was the Sydney Opera House. So one night she attended a farewell drinks function for an employee of the Sydney Opera House. She was the only employee from Ryan Wilkes to attend. At that function, though, she became intoxicated and was allegedly overheard insulting a colleague and employees of the Sydney Opera House. She allegedly propositioned a Sydney Opera House employee, and she vomited and had to be escorted to a taxi because of her intoxication. Now, after the function, her employer was notified and an investigation was undertaken, and Ms. Pushka was interviewed along with a number of other staff. Now, the employer's most serious finding of misconduct of Ms. Pushka involved her making propositions of a sexual nature to a Sydney Opera House employee, but the primary evidence upon which the employer established what it regarded as sexual harassment was provided by anonymous statements of two managers. Ms. Pushka, she strongly rejected that she had made propositions of a sexual nature to the client's employee. Despite this, though, she was summarily dismissed for serious misconduct. The Commissioner in this case agreed that the employer had a reasonable basis to investigate misconduct in relation to Ms. Pushka's intoxication, despite it being an after-work function, on the basis of the potential negative impact her conduct could have had on the renewal of the employer's contract with its major client. However, despite this position, the Commissioner found that the findings of the investigation didn't support the decision to terminate the employee, let alone summarily, and it noted that, frankly, if one act of inoffensive drunkenness at an after-work function provided a valid reason for dismissal, I suspect that the majority of Australian workers may have potentially lost their jobs. Now, the Commissioner also noted that summary dismissal as a form of dismissal should be treated with the appropriate gravity, deserving of a decision that records very serious wrongdoing. It's implemented without notice or payment in lieu, and it can prevent access to some accrued entitlements like long service leave. Now, the Commissioner found that the employer didn't undertake a full and proper investigation into the circumstances surrounding misconduct during the farewell drinks function. The applicant was not given sufficient details of the misconduct that was alleged against her, and she wasn't allowed a proper opportunity to respond. The employer should also have heard directly from some witnesses before it accepted the version of events from anonymous managers. And there was also CCTV footage that was available from the evening in order to properly evaluate details of the applicant's conduct during the period of her drunkenness. So leaving only Ms. Pushka's act of vomiting and needing to be assisted to a taxi as grounds that could be relied upon for dismissal, the Commission found that this conduct did not constitute a willful act on the employment relationship and that it was not of adequate severity to justify dismissal with notice, let alone summary dismissal. Additionally, the Commission found the employer's failure to suspend Ms. Pushka, in fact, allowing her to carry out her duties as usual for over a week before dismissing her, prevented the employer from then opting to summarily dismiss her. This would appear to be because their continued working relationship indicated that their employment relationship could have continued. So the Fair Work Commission, in finding that the dismissal was unfair and ordering reinstatement, held that the dismissal was without valid reason related to her capacity or conduct, and the procedure that the employer adopted when it investigated and determined the allegations made against Ms. Pushka denied her procedural fairness and natural justice. You could, however, see in a similar scenario that if, while there was a connection to the employment, had they undertaken a full and proper investigation that substantiated allegations, that it might have been a different outcome.
So you may have heard about Rose and Telstra before, and even Pushka. For those employers in the New South Wales Industrial Relations Commission jurisdiction, it's important to note that the New South Wales Industrial Relations Commission has actually taken a different approach and has not actually adopted Rose and Telstra in many of its decisions. Partly it's because it's not bound by Fair Work Commission decisions, and those decisions are actually informed by the Fair Work Act. But also, one would say, some would say that the Industrial Relations Commission, unlike the Fair Work Commission, takes a more holistic approach to assessing all relevant circumstances, including that many of the employers who appear in that jurisdiction have employees who are in service of the Crown in right of the state of New South Wales, and as Crown or employers or civil servants working in government roles, there are different considerations. So McFarland and Corrective Services New South Wales is a good example of how the Commission distinguished the different nature of New South Wales IRC Commission jurisdictional employment. So in 2015, Mr. McFarland, who was a correctional officer at the John Moroney Correctional Centre, assaulted a fellow work colleague, a Mr. McKay, outside of work hours, whilst he was intoxicated. He was actually then sentenced in separate criminal proceedings to 100 hours community service, and was also restrained by a apprehended violence order by Mr. McKay for a period of 12 months. Mr. McFarland was dismissed, having regard to the serious nature of the misconduct. He made an application for reinstatement for unfair dismissal. His dismissal was found not to be harsh, unreasonable or unjust, which are the words used in the New South Wales Act. The New South Wales Commission was prepared to accept in these circumstances that an assault outside of work hours aggravated by intoxication were sufficient grounds for dismissal, as the and also because the conduct ultimately gave rise to criminal proceedings. Importantly, and this is I think what distinguishes New South Wales cases from the Fair Work Commission cases, this employer was required to adhere to the Government Sector Employment Act, which expressly provides in the definition of misconduct and of any offence that's punishable for 12 months or more, and his assault findings were one that could have resulted in that, even though he was given a lenient community services order. Further, much like many in the government and public sector in New South Wales, he was bound by a guide to conduct and ethics as a correctional officer, and this guide actually covered conduct whilst off duty. And the Commission noted this because evidence by the Director of Custodial Corrections of his employer included that there was a high level of intoxication, and Mr. McFarland was aware of his obligations, and it was no excuse for him to be intoxicated, to not able to control his behaviour, which in effect resulted in a violent action void of any self-restraint, and that was important in his role, regardless of whether or not this happened outside of work. And also, importantly, the employee made no representations or promises that he'd taken any steps since to address his alcohol abuse problems, or that he was able to exercise self-restraint when consuming alcohol. So that was a surprising omission by the employee in his evidence that was taken into account. So the New South Wales Industrial Relations Commission was satisfied that in all of the circumstances, the employer had justifiably lost trust and confidence in the employee, taking into account core values, which were sourced from the Government Sector Employment Act, but also public sector, government sector obligations to be a person with integrity, trust, professionalism, being aware at all times of safety and well-being of other staff and other people, but also having public duties, including when off duty from work, to also be a person who is acting with integrity, honesty and obeying the law. Again, it's interesting the Fair Work Commission cases don't look at those sorts of obligations. Now let's quickly look at environments where mandatory testing regimes are in place. Firstly, it can be confidently said that industrial tribunals have accepted, at least since the late 90s, that the implementation of mandatory drug and alcohol testing is reasonable and a legitimate employer response to safety risks. And I can say that because an appeal bench of the Fair Work Commission has said so in the quote that's on the screen. In the case which concerned this appeal by Briggs, Mr. Briggs argued that because his employer's mandatory policy on alcohol and drug misuse only provided for testing of employees for impairment whilst at work, a direction that he was given to undertake a urine test could not be reasonable because he claimed that test would not be able to detect impairment. And to support that argument, Mr. Briggs relied on an Australian standard which emphasised that urine testing and the standard used was not relevant to impairment. However, despite that interesting argument and somewhat, I suppose, legitimate argument, the full bench, the Commission, still found that the employer's direction and policy was reasonable. It's because the policy and the requirement is not something that's exists in a vacuum. It did not involve abstract or unconfined assessments, and it doesn't need, the Commission didn't need to look at the justice or merit of the direction. It just needed to be demonstrated that the employer was doing so in circumstances of trying to reasonably practically ensure work safety. And it didn't have to prove, the employer didn't have to prove that it was best practice or in the best interests of everyone. And again, thankfully, the Commission full bench said the proper approach was to consider all the relevant circumstances, including the nature of employment, the established use of mandatory testing in that industry or common practices in that industry sector, whether or not industrial instruments, awards, enterprise agreements said something about testing, which it did in this case. And also, importantly, Mr. Briggs's own contract of employment included an express clause requiring him to comply with policies, including on in relation to drugs and alcohol. So this point in itself was enough to say, well, look, not only was it reasonable, but it was actually lawfully necessary for Mr. Briggs to be undergoing urine testing, and the testing itself was not unreasonable in all the circumstances. So that's a positive sort of re-endorsement of mandatory testing. The case of Raycheck and DP World also adds some support to the reasonableness of mandatory testing processes, particularly in high-risk work environments. In this case, the employee actually had 23 years service, starting work as a stevedore in the mid-90s, which was a tumultuous time on the docks in Sydney. He accepted, admittedly, that the work environment that he was in was safety sensitive. He needed to perform stevedoring duties with the highest level of safety standard adherence, and that he himself had obligations, as did his colleagues, to ensure safe work. The drug and alcohol policy in place had a sort of a tolerance or a drug of a reading of no more than 1.118% within 30 minutes. So that was very precise. It wasn't zero tolerance, but a tolerance that some would say would be reasonable considering similar drink driving laws. He attended for work in April 2018, and for some inexplicable reason, he turns up with 5 cans of wild turkey, of all things, in his bag. And within 30 minutes of commencing his shift, he'd already drank 4 to 5 of those cans. And who would have known that that drink was such a thirst quencher? But sadly, what became apparent is why he did this was because he sent a note to a work colleague saying, "Tell my family I love them with all my heart, please, I am sorry." So he was then found standing near a hatch, open hatch, ready to jump on the docks. He was talked down after 30 minutes, but quite remarkably, instead of being sent home, he was actually allowed to return to work. And then the employer chose to select him for random testing, and he had a blood alcohol reading above the limit. He then strangely told his employer that he had gone to lunch and had a few drinks, and even more strangely claimed that his drinks must have been spiked, so that wasn't a helpful lie. His employment was terminated. He wrote to his employer 2 days later begging for his job back. His employer stood by its decision. So in the hearing, the employee argued that in light of all the extenuating circumstances, it was not sufficiently serious for him to be dismissed. And although there was a policy on this, he said that he claimed that others who had been impaired at work or had not passed the test were still allowed to continue working, were not dismissed. He also, not surprisingly, claimed that he was suffering from severe depression at the time, including by contemplating taking his own life, and therefore it was an unfair dismissal. However, the Commission found there was a valid reason to dismiss, accepting that the nature of the work environment was highly hazardous with a very small margin of error. The policy itself, whilst it did not mandate termination of employment, it was also accepted that it could. And importantly, because the employee's reading at the time was nearly 6 times the limit, which is an alarming limit, the Commission was satisfied that the conduct was seriously in breach of the policy. It was also satisfied that because there was no medical evidence backing up the employee's claim of severe depression, it couldn't make a finding there. But in all the circumstances, the decision to dismiss him was not disproportionate to the gravity of the breach, and was also satisfied that dismissal was not harsh considering the risks that were involved. So the lessons from this decision is, perhaps the policy should have been clearer about whether or not dismissal would always occur, but it probably was appropriately flexible because there was a toleration and accepted sort of limit of being affected by drugs or alcohol. How to test that? I obviously had testing facilities on site. Not everybody does. What could have been done better or differently? The Commission did note the fact that Mr. Raycheck had apparently attempted to end his life, and in fact was talked out of it. However, returning him to work was evidence of a systemic failure in DP World work health safety practices, and I think most of us would have thought, well, look, there probably would have been a better intervention there rather than sending him back to work to be, set up to fail on testing. Perhaps there should have been a more sensitive attitude taken to have him cease work, then to have himself assessed outside of the workplace, or actually extend EAPs or other services to him. So I think we could all think of other things that could have been done better, but it is an alarming case that there are obviously other issues that resulted in him consuming that much alcohol at work in the situation.
So while there was criticisms of DP World by Fair Work in relation to its work health and safety practices and the alcohol and other drugs policy, it looks as if by 2021 DP World had sort of cured some of those issues, because we've now got a recent decision as recent as this month, in Craig Hancock and DP World Brisbane. It's a full bench decision, came out I think on the 2nd of September this month. So in this case, Mr. Hancock was denied leave to appeal a decision at first instance by Commissioner Spencer. The Commissioner had found that his smoking of cannabis, the employees that is, by an employee outside of work hours was a breach of the employer's lawful drug policy, and not because he was impaired. As such, his subsequent dismissal was considered fair and reasonable. Now, the facts of this matter was that the applicant, Mr. Hancock, commenced work with DP World in 1996 and was a stevedore at the Port of Brisbane, where DP World operates container terminal. He had completed a 7-hour shift and he was randomly selected for a drug and alcohol test in accordance with the AOD policy. He received 2 positive tests for THC, a compound that's formed in the body after consumption of cannabis, and then he was issued with a show cause letter to attend a meeting. Now, at that meeting, he was informed that he had engaged in serious misconduct and he was dismissed effective immediately, which was confirmed in a termination letter where DP World said that the applicant had breached not only its AOD policy, which provided that it was the employee's responsibility to be fit for work, including being free from drugs and alcohol, but he'd also breached their critical safety commitment, which talked about presenting to work in a fit state to perform duties and be free from drugs and alcohol. He breached his contract of employment, which required that he was expected to comply with DP World policies and not attend for work with the presence of drugs or alcohol in his system, which may impact his capacity to work safely or competently. And he also breached their employee handbook about the personal responsibility of their people to ensure that they're fully fit for work. Now, Mr Hancock argued that he had not been afforded procedural fairness and that the Commissioner had failed to genuinely consider his 25 years of exemplary service. He said he struggled with mental health during the pandemic and had consumed cannabis to help him relax every evening for 16 days, including the evening before he was rostered to work. He was aware of the AOD policy and that it was lawful and reasonable, but that it was lawful but unreasonable because it didn't inform employees what conduct to avoid to ensure it didn't breach its terms. And he argued that his work was not impaired. Commissioner Spencer, in finding that the dismissal was not unfair, held that there was a valid reason, as the applicant had conceded he consumed cannabis every evening for 16 days, and the high-level reading was 37 times the cutoff of the Australian standard. His role was also safety critical. He had seen the employee handbook and was aware that it said that termination was a potential consequence of attending for work with drugs in your system, and he was aware of the policy. So they found that the policy was lawful and unreasonable and that he wasn't dismissed unfairly. Now, the full bench, in denying permission to appeal, they found no error in the decision of Commissioner Spencer, and that they held that the applicant wasn't dismissed because he was impaired by cannabis, but he was dismissed because he failed to comply with a policy which provided for dismissal as a disciplinary consequence for a positive drug test. They also noted that the Commissioner had made it perfectly clear that his length of service did not give him licence to breach company policies, and further highlighted that they'd weighed up the worker's remorse against the fact he knowingly consumed cannabis the night before his shift. So in that case, the AOD policy and DP World's practices stood up to the test.
Well, in the time we've got left, what about drugs and alcohol as an area of potential discrimination? This sometimes comes up, particularly in the context of addiction to prescription medications or opioids, which has been found to be a disability, both in federal and New South Wales anti-discrimination law. Marsden and the Human Rights and Equal Opportunity Commission, a 2000 case, is a controversial example of this, where Mr. Marsden, who was a member of the club, alleged he had been discriminated against when he was denied access to liquor and subjected to other detriments, including depriving him of membership to the club and its facilities because of his disability, which he said included opioid dependence, the use of methadone, and a condition of hepatitis C infection. The then Human Rights and Equal Opportunity Commission dismissed his complaint. A review was sought in the federal court. It was accepted, though, by the federal court that opioid dependence addiction could be a disability, and the definition of discrimination was broad enough to include in the sense of being deprived of membership or access to facilities to be less favourable treatment to him than somebody in the same or similar circumstances would have been treated, who did not have that particular disability. So it is possible, whether or not, I mean, there's certainly since that case, the issue of opioid dependency and other prescription drug dependency has become more well known, and sadly, partly because of COVID sort of isolation and being at home. However, discrimination on, whilst discrimination in the New South Wales Act is prohibited on the grounds of addiction to prescription drugs, it does not extend to prohibited drugs. So if we go back to our hypothetical where there was drug paraphernalia with non-prescription or prohibited drugs, that would be something that would be excluded from discrimination.
I'll now turn quite quickly to management of drugs and alcohol in the workplace, and just to finish off to say that when contemplating and making decisions for drugs and alcohol, there are obviously risks and considerations that you need to bear in mind. As we've touched on, there's safety issues. Employers should consider the workplace culture and practices that they may have in their workplace that encourage drug and alcohol use and patterns, and other workplace factors that might influence employee drug and alcohol use, such as physical and environmental factors and characteristics of the job. It's also important to appropriately manage due to the risks to workplace harmony. Some of those risks can include inefficiencies, tardiness, absenteeism, and accidents at the upper end. And in terms of managing this type of behaviour in the workplace, including by termination of employment, you'll also see risks of claims of unfair dismissal and general protections. We've touched on some of those relevant case decisions. And also, finally, there's potential for discrimination risks, which Darren just briefly touched on.
So I suppose there's an interesting sort of overlap of obligations, considerations, and concerns. Again, welcome any feedback or questions you have on these issues, but again, I think you need to sort of consider what is the work environment, where work is being performed, what are the real risks, have they been properly assessed? Those risks can include reputational risks too, and I think they're often forgotten. Do you have a definition in policy or in regulation that applies to your business that serious misconduct can include merely being intoxicated at work? That's often a helpful plank in supporting a decision, at least in terms of demonstrating that there's a valid reason for a dismissal. Whether or not it's summary dismissal, as always, that raises the bar in terms of having to prove why not affording an opportunity to respond was given. And as some of the cases we've gone through have explained, there may well be health or welfare issues that are behind employee drug or alcohol use that perhaps should have been explored or could be explored as being a more sensitive and alternative approach to managing employee health and welfare at work. But it's also, and in that sense, it's important to consider, are there other reasonable alternatives? And we touched on those, including is there EAP or other support assistance that should be considered first before dismissal, or before other risk manage approaches to ensuring that mental health, fatigue and other health impacts don't create harm to that employee or others. But we certainly welcome your feedback and thoughts on the topic. I hope you enjoyed what we managed to cover in the hour that we had. We're very grateful for such a large audience, and our contact details are attached to our slides should you have any questions. But we've got a little bit of time, if you do, to answer anything online now. No, well, again, feel free to send feedback at any time. Thank you again for your attendance, and don't forget that there will be a survey and questions to help us customise and deliver what you want to know about. Thank you very much.
Thanks, everyone.